Hello, my name is Lauren Bavitz Fields, and I'm a family law attorney on the domestic litigation team at Roth Davies LLC. Today I'm going to be discussing property division. You file a petition for divorce. Now what? Do you have a home together? Do you have retirement accounts? Do you have investments? Do you have stocks? Perhaps you even own your own business. You also might have a lot of debt. Do you have student loans, credit card debt, automobile loans? Sometimes the assets and debts can be jointly held, and sometimes they're in your separate name. In the state of Kansas, filing a petition for the divorce lets the judge determine all of the assets and the debts in the division, even if they're separately named and titled. So for example, if you have a retirement account in your own name, then that can also still be subject to the division of the court, even if it's separately titled. So how does the court determine how to divide the assets and debts of the parties? Well, the first and foremost consideration that they look at is what is fair, just, and equitable. What is fair, just, and equitable does not necessarily mean a 50-50 split. There's a common misconception that the judge will only divide everything 50-50. It depends on a lot of factors. The court has statutory factors that they must consider in the division of the assets and debts. One of them is the age of the parties. Have the parties only been married for a couple years, or have they gathered all these assets and debts together in a joint venture over 30 years? Another factor that they look at are family ties. Does one party have significant assets through an inheritance or through a trust account? Or are they completely on their own? Another factor is the length of the marriage. This is important for the determination of assets and debts and maintenance, which is spousal alimony in Kansas. Have you been married for a very long time? That is an important factor for the judge to consider in dividing the assets and debts. Has one party given up their career and become a homemaker? That is another important factor in determining the assets and debts of the parties. Another factor is the tax consequences of dividing assets and debts. This especially comes into importance with dividing retirement accounts. Although there's not a tax consequence of dividing retirement accounts pursuant to divorce, there will be tax consequences later on when that party decides to withdraw. Another factor is the dissipation of marital assets. Dissipation of assets means one party, for whatever reason, has spent a lot of money. This can be gambling. This can be an adulterous relationship. This can be a bad habit, such as shopping. If you can prove dissipation of marital assets by one other party, you can ask that the court take that into consideration in dividing the assets and debts of the marriage. One of the last factors, the time, source, and manner of acquisition. For example, if you had a lot of assets coming into the marriage, then you potentially can have all of those assets awarded back to you as premarital property, and that request the court only divide any marital property that was received after the fact. You can also request that any appreciation of assets be only considered and that you were returned your premarital entry value of that property. Another factor could be how you received a piece of property through a business or through your family. Perhaps you received an inheritance of a piece of land. You can request the court not include that in the marital estate. The judge does not necessarily have to award inheritance back to the person that received it, but likely if you can prove and trace that you have a good shot of getting that inheritance moved back to you. If you have any other questions about the division of assets and debts and how the judge considers all of the factors, please call Roth Davies at 913-451-9500 and speak to a family law attorney today.